Happen. Now, Ross, I haven't seen you in a couple of weeks. It's good to see you.
Good to be here.
I'm glad you can make it. We're going to be talking about restraining orders. And this episode, we're just going to keep it loose. We're going to talk about a lot of things and see what kind of response we get, because I like to, in the future, the near future, really get a detailed one, because I know a lot of people will find this very interesting, or,
A lot of people.
or in the need of a restraining order. And I'm sure there's pitfalls.
I get a call a week.
Okay. Let's talk loosely about it. We got about 20 minutes, 25 minutes or so. Let's go over all the basics, then you can figure out, or maybe we can get some calls here, 254-697-6633. Have some questions asked that you could use, write down, and maybe for the next show have a detailed outline.
Yeah. I think first, like I say, I get a call a week. Some of them have no merit. Some of them are interesting. Some of them, are serious. Some of them are very concerning. A lot of them very ambiguous and vague. You have no idea what's really going on. You feel like there's more and they're not telling you.
Right.
Okay. It really depends on what's going on every one of these things. If we're really talking about stalking and harassment, and I get calls with people saying, "Hey, this guy keeps texting me. I want him out of my life. I'm getting a divorce, or I want to break up with him, or he's in my house. How do I get him out of his house?" All of these kinds of scenarios that create different kinds of problems. Sometimes there's the threat of violence. There's violence in the past. Sometimes there's just a very controlling person that hasn't actually done anything violent ever. Sometimes there's the individual that really is just trying to take advantage of the other spouse or significant other, the paramour, right? By either taking property, right, cutting off maybe some kind of service to the house, or is maybe trying to take control of the property so that they can, in other words, when I say the property, the house, so that they can dispose of assets and the other person won't be able to fight them or know about what they're doing.
Well, how do you get to the truth? Because there's three sides to every story.
That's right.
His, hers, and then the truth, right?
And then whatever the judge or jury thinks.
That's right.
and so if you really got a problem, I think for those that when I say really have a problem, you should know who you are. If there's been a situation in the past where it's been violent, and there's a history of family violence, and and that's a legitimate. When I say family violence, I don't mean you had to go to court either. Maybe you're one of those people who likes to keep things between yourselves and don't really call the police maybe like you should, and take action through the authorities. But what I mean is, if there's been violence, if there's been some kind of physical contact in the past, and that's going on right now, you need to just go to the police. Okay? And I've seen this many different ways happened, and even in Milam County. And what might happen is, depending on the severity, maybe they don't have a family violence case this time. Maybe you just finally decide to go to the police department, and you'd say, he's hit me several times, or she's hit me several times in the past, and now he or she has not hit me or been physical with me, but this person has been really aggressive, and I'm trying to leave, and all these things are going on, and I don't know what to do, and I need help. They may either help you fill one out, or they may send you to the district attorney's office to have the district attorney help you fill out what's called a protective order. And the protective order is really to prevent family violence, right? It's to prevent the physical contact, the aggressive behavior between your paramour or your spouse. It's really to protect the integrity of the family unit, okay? Because we don't want violence going on between families, especially if there's children involved, and we don't want things to either Hatfields and McCoy, so to speak. You don't want this family getting mad at this family because of something that's going on between lovers, so to speak. Does that make sense?
Taking what you said at face value, get it. But what if you got this history, and then let's just use the woman as the example.
Closer to the mic.
Let's just use the example of a woman who's being assaulted by her significant other or something, and she gets to a certain point and she goes, "I had enough. I want a restraining order." How do you just get a restraining order without some type of evidence? Because the guy could be like not doing that, and she's just a nutcase or wants to do something, cause mischief. How do you prevent that from happening?
And that's exactly right. That's why I'm kind of torn, because you've got to say, look, you got to tell this person when they come in your office and say there's a serious problem. You got to say, look, you got to take this serious. You got to swear to an affidavit usually, right? If you want immediate action, you're going to have to take an affidavit. You're going to have to swear to these facts and show that, look, there are, like I said, that's why we're going to have to come back and do a second show. There's probably 15 different statutes on the books as far as what can be done through some kind of temporary order or what's called ex parte temporary orders. And ex parte just means that it's you and the judge one-on-one. There's no adversarial process, and it's done to be quick and immediate. And so in all these kinds of temporary orders, usually what we're looking at is there's some kind of necessity. Okay, there's some kind of necessity for action, and there's some kind of immediacy, if that makes sense. There's something that is necessary and immediate that needs to be done. Sometimes we're looking at, is it necessary and appropriate? Okay, if we're doing, and you're going to have to swear in an affidavit, you're going to have to put on evidence, you're going to have to convince the judge in an ex parte proceeding that, hey, I really need this now. This is a problem. There's also some standards called clear and present danger. Okay, we have to sometimes present evidence that is substantial, that there's going to be detrimental effect on the welfare or health or safety of somebody, maybe kids, for instance. All those things are going to require an affidavit swearing that this is what's going on. Then after you get the judge to grant that ex parte order, okay, what's going to happen is you're going to have a hearing. Normally the time periods are normally 14 days. Got to have some kind of hearing in 14 days. And so you come back, and these things can get really, really contested. I mean, a lot of times I tell my clients, for strategy-wise in a family law case especially, winning the temporary orders hearing is like winning the case. Now, that's not always true. You still got to go. You can still go and have the jury trial. You can have the bench trial, and you can win at the bench trial, even if you lose at the temporary orders hearing. But the temporary orders hearing is going to be at the outset of the case. Okay? And you're going to be asking, hey, judge, I want this for custody of my kids. I want to get child support in this amount of money. I want to get have a restraining order that he can't touch the bank accounts, that she can't, control the cable bill, that, maybe you're wanting spousal support. All these things can be taken up in a temporary order at the outset of a case before you've even had a chance to investigate and develop a case, and even where the attorneys sometimes even know what's really going on. Okay, and so that's why sometimes these things are unfair, because it's like sometimes it's a surprise type of thing to the other side. They don't even think you're going to get a divorce. They don't even know there's a problem, and all of a sudden, boom, they're served with papers. You got a temporary orders hearing. They don't even have a lawyer. It's going to take a week for them to find a lawyer, right? By the time they find a lawyer, that lawyer's got 2 or 3 days to prepare and call witnesses. How are you going to subpoena people in a couple days, right? And it's just unfair a lot of times, some people feel like. On the other side, if it's not done quick, right, it gives the other side a chance to manipulate the situation. Okay, and sometimes people need this quick action because there is something serious and dysfunctional about the internal functioning of the relationship.
Well, a lot of people, I know my initial thought was restraining order was physical abuse.
No, this could be property.
And property, now you're listening to all those things, and I can get it. So it's almost like a pre-calculated strike against
It is.
the person.
So I tell folks all the time that come in for a family law case, I hate to say this, it's terrible that it is this way, but it is, based on our system, a game of inches. Okay, family law cases are a game of inches. I've seen the tides completely turn a 360, right, in a 3 or 4 year period. Completely turn around. One spouse has sole custody, right? Sole custody. There's a presumption that both parents should be involved, joint managing conservators of the children, both be involved jointly in the raising of their children. Even though one may have first, third, and fifth weekend, they're still got mostly equal rights. But I've seen cases go to sole managing conservatorship, where one parent has complete control, right, and the other one has supervised visitation, okay? And just slowly over time, that parent that doesn't have anything just files and keeps filing, and just gets a little more every time. Gets joint, then they get joint with extended, then they get joint with maybe an extra day of the week, and then the other person messes up one time, boom. All of a sudden, they go for temporary orders. they're moving for temporary orders right away. Maybe CPS got called once. Judge, there's a problem. There's a safety threat to my child. CPS is involved. I think I should get custody of the child. So, and they go to temporary orders. That's what I'm saying. It's strategic at the outset. You've got to win that hearing because that sets the tone for the case, right? You take sole custody and temporary orders, boom, because there's a safety threat. Now, the other side probably ain't getting the kid back unless they've got really good evidence. They may come back and get joint managing conservatorship, but it's a good chance. I've seen this happen. I've seen this happen many times. Okay, but when we're talking about, let's talk about safety threat to you. Okay, and
I mean, that's basically what the show is about, but the other aspects are extremely interesting, and I want to talk about. So, but let's touch on this one first, because there's some, and the reason I brought this up was I've had a few people come up to me, ladies in particular, saying, hey, the need of a restraining order, I need a gun, so on and so forth. I'm just thinking, man, there's a lot of stuff out there, so let's hit that first and see what we got. And everybody's 254-697-6633. If you got a challenge, give us a call.
So, when we talk about a safety threat, maybe we're talking, now, that's what I said, when you talk about these types of injunctions, temporary restraining orders, temporary protective orders, the TPOs, the TROs, we could have it play 6 different chapters, or 6 different codes even. We could have the penal code, family code, government code, local government code, as well as different aspects of the juvenile code which fall under the family code. But you could have just several different even code sections applying to one scenario. And so when we talk about stalking and harassment, man, family violence is one thing, but these I've seen people just get.
Well, let me ask you.
I've seen people get screwed over. Excuse my French.
Both ways. That's why I want to ask you this question. Let's say somebody feels like they're being stalked. Maybe they're just super paranoid. Okay. Maybe let's use a guy and a girl.
Maybe they're just vindictive and they want to go.
That too. So first of all, let's set this up. Anybody can go get a restraining order as long as certain criteria is met. However, if they're faking it and messing around, what's the aftermath to them that can happen legally if they're not telling the truth or they lie under that affidavit? So to make it preventive, like supposedly the death penalty is supposed to make you not kill people. Well, that ain't working too well. So
you know me, I try to be honest and realistic.
That's why people listen.
I tell the good with the bad. And I try not to disparage any public officials directly, but we have a lot of good ones, and I don't disparage any public official directly usually because they have a tough job. And
just don't say no names.
No, I'm not. No, that's what I'm saying. I don't do that because they have a tough job, and a lot of times they don't know who to believe, and a lot of times I'm a good defense lawyer, okay, or I'm a good. I don't necessarily think of myself as a defense lawyer, but
that's why you're on my speed dial,
right? But if I'm good at what I do and I go in there and kill the DA's case and make it look like the other person's lying. The DA doesn't always know if the person's lying or if I've just done a really good job of doing my job. Okay, and so sometimes I'm just going to tell you, most of the time, right, nothing happens to these people when they make up false allegations. Okay, and sometimes it's because it's hard to know, right, that they're actually making it up. Just because the DA goes and loses doesn't mean they were lying. Okay, from the DA's standpoint, they put faith in the person that's come to them and made these allegations, and they would hate to go after somebody. Maybe the person did lie, but maybe they lied because, for lack of a better way to say it, for a good reason. Maybe there is a problem at the home, and the person has gotten beat before, and they know that it's about to happen again, and so they go and make something up before it does. There's all kinds of reasons why they don't prosecute these people, and I just didn't want to think that I'm saying these public officials aren't doing their job by not prosecuting people who make up false allegations. What I'm saying is it's hard to know sometimes. Mm-hmm. Okay, so with that being said, you can get charged for making a false police report. You can get charged for perjury. You can get charged for forgery of a government document. You can get charged for abuse of process. You can civilly, when we're talking about speaking, I can come after you for malicious prosecution, which I have. A jury here in Milam County returned a verdict in favor of my clients, right, for $4 million. Okay, because the lady made up several false allegations, made in court after court, in proceeding after proceeding, right? Lied to me in deposition, right? And the thing about the CPS allegations is you can call CPS, and that's confidential, that's privileged. People can't see who's making these false allegations, and so you've got to go to the judge and ask the judge to disclose who the reporter is, who's reporting all of this child abuse that's not happening. Okay, and lucky for us, in that case, the lady lied to me in deposition about everything. Okay, and I had all that recorded. And then we go back and we got the judge to disclose all the CPS records. And lo and behold, everything she told me in the deposition ended up being false because of what the other ones. And so it showed a clear plan or scheme or system, right, to harass the other side with use and abuse of process. Okay, and so these things happen all the time as well. And, I mean...
So if the person on the other side is getting lied to and made to look like the bad person, what's the tip to give them? Keep it cool?
Yes, and so I want to say this too. If you think somebody's making a false allegation of child abuse, this happens probably more than... This is in the top. I get these happens all the time in these family law cases. But if this is happening, you need to tell the lawyer... And you need to, if they don't mention it, they need to. The lawyer needs to know you can actually get attorney's fees, you can get court costs, and you can actually have a different determination of child custody based on the fact if the other side's made false allegations before. A lot of people don't ever make that claim, and they should. I don't know why it's not used more. The family code actually makes it available if somebody's made a false allegation. That is a reason, okay, to deny them custody or to modify, right, the custody or even the temporary orders that we just talked about that might have been entered. So if you go to temporary orders hearing and they're talking about a bunch of allegations of child abuse or safety threats, okay, and you go through discovery and you find that those things were baseless and made up, maybe even false on purpose, perjury, so to speak, you need to ask for a modification immediately, and you need to use that provision and say, Judge, this is a reason for me to modify, and I want them to pay for my attorney's fees. I want them to pay for what they made us go through and pay for all of this hearing and expense that we've had to go through. And you need to use that. And if you do use those tools, I mean the judges will listen to that. If you think you got some kind of falsity going on, they're going to listen to you. And I know we started on stalking. Okay, so and you ask about evidence. How do we do that?
It's such a clover leaf. There's so many different aspects to think about. So you get off on these tangents, but it all comes back to the center. But go ahead.
People, I think, need to be more direct today. People are always worrying about people's emotions and, what about this and this and that. If you want to break a relationship off with somebody, you just need to tell them, hey, I don't want to see you anymore. That's it. Don't beat around the bush and make this person, worry about it and get attached and then, start getting paranoid, and that's when people start getting crazy. Okay, just tell them straight up, boom, and then until you have a clear case. If you tell them, I don't want to talk to you anymore, stop contacting me, and they keep contacting you, then you're going to have a case to go to the police about, go to the district attorney about, and say, hey, I told them to stop, they didn't stop. When you're saying, hey, I don't really want to talk anymore, and they text you back and you say, look, I'm kind of busy, and they keep going. You're not really telling them to leave you alone.
Yeah.
So don't come in my office saying you want to go after this person, right? Or you want me to do a protective order, and you've not been clear with that other individual about, hey, I don't want you contacting me. Okay? Now, you need to take it serious as well. Okay? You make sure you save your Facebook. Make sure you save your text message. Make sure you save your emails. Print that stuff off. Take screenshots. How many times have I had people come and say, well, I got a new phone, or, those are on my other phone. Well, transfer them over. Don't come in here and tell me that all this stuff happened and then not be able to show me when you're telling me it's all in text messages. If it's all in text messages, show me. Because if you don't, it's suspicious why you don't have them. Mm-hmm. And, I've had a lady on the stand. I think a lady on the stand told me a piece of paper ain't going to stop a bullet.
Yeah, I want to talk about that. I want to talk about that a lot. Let's clarify. Here, let's use a woman example.
She's
being aggressed upon. She gets a restraining order, and she thinks, hey, I've got this piece of paper. It's like this imaginary shield. and it doesn't mean squat. It's worth what it's written on. So go ahead and hit it, Ross.
It's worth it, and here's why. Here's why you still need to get the paper.
Well, I understand you need to get the paper, but
Here's why you need to get the paper. If you can get the protective order, right? Once he violates and comes within a certain distance from your house, right? You call the police right there. He's committed a felony, and they can go and they can arrest him. That's probably a reason to deny his bond. That's also a reason to give him a 24, 48-hour hold at the jail, even if he could post bond. Okay? And that would give you a way to get out. It'd give him also a reason to say, hey, we're serious, and now you've got another charge on top of harassment. So now you've got harassment, you got violation of a protective order, right? And it's also something that we can enhance, right? You've got a criminal trespass, right? You've potentially got, if they come in the house, you've got a burglary.
how does that work on a restraining order? Let's say it's a 300-foot restraining order, and you just said what you just said, and the person who has the restraining order sees that. Let's just say they got a marker, and they know, hey, he broke that plane. What type of self-defense maneuvers can they use for protection? And if they feel, hey, I'm scared, he broke the restraining order boundary, and now I'm in threat. Does that eliminate the need for inside of your home? Let's say you're in your home and he's outside in the front yard, but he broke the 300 feet. Does that eliminate the boundary lines of the walls of your home, your perimeter?
That's a good question, but I think that you still would probably get the presumption because you've got a right to be where you are. You have you're at your home, so to speak. You're in a protected area. You already have a finding that there was a potential immediate necessary threat for violence. And so if you've already got this legal finding that there is a potential threat to you of immediacy and necessity, then how would the state ever say that you could not have formed a reasonable belief when the whole point of that perimeter, okay, is to keep out a threat that was immediate and necessary for you to take action.
That doesn't mean to snipe them out immediately. I mean, but it just gives you that.
And that's why I'm being very careful when I talk about this. I don't want to just say, "Oh, you've come within this. I'm just going to pop off and shoot you." But and that does not help families be conducive and work stuff out. But at the same time, if you've got the restraining order and it says don't go within 300 feet, you got no business going within 300 feet.
I mean, I guess it depends on what the restraining order is. I mean, you told me, or you made comment, if I understood correctly, there's different types of restraining orders.
So sometimes it's to the specific place, and sometimes it's to the specific person. Now, I would say that it's different if we're talking about 300 feet to the person, because let's say we're in Cameron, and you have a married couple, and there's been something stupid. I mean, I've had stupid cases. I mean, I really have, and the police go ahead and charge it, and the DA never does anything on it, right? But DA doesn't have to do anything for there to be an emergency. And we didn't talk about EPOs. If there's been a violence, if there's been a family violence involved, they're going to do what's called an EPO, an emergency protective order, and that goes to the JP. Here, a lot of times, Sam Barry's seen it. Gosh, a ton of these. Okay, and I've even been in his court, trying to fight these things, and you might have a situation where somebody just took offense, maybe just a light touching or something like that, and all of a sudden it gets blown out of proportion, and we got this family violence case, and we got an emergency protective order, and the emergency protective order say 300 feet from the person. Well, what if you go to your kid's baseball game, right, and that other person's already there for the kid's baseball game, right? You can't just, no, you're not going to have any kind of right to self-defense, right? If you're in the grocery store and the other person's on the other aisle and neither one of you knew that the other one was there, okay?
Well, that's common sense, but that's not too common sense.
Right, but that happens a lot. Those are the problems with these EPOs. And so if you're in your house or it's to a location, that's one thing, and this person's obviously violating something that is something of finite nature. There's nothing ambiguous or argument to be made about don't go 300 feet from the house. You know where the house is. The house doesn't move. You know where you are in town. You've been there before. Don't go there. But it's different when it's to the person, and maybe you're at the grocery store, or the movies, or at a restaurant.
At that point in time, you just acknowledge and say, I'm backing off.
Right, and what I find amazing is is that we'll get these protective orders, and the judge will just tell my guy, if you talk to her, or he, or you talk to him, you're going to be prosecuted and blah blah blah. And the other person that got the protective order will then start text messaging, right? And I love it. Sometimes, a lot of times, they'll start sexting, right? The other person, like, because then they start getting lonely, right? They kicked this person out of the house. They got the protective order and kicked the person out of the house.
Tangle web we weave, man.
I tell you, these are great. These are great. I guess fun cases, so to speak. If this is what you like to do as a lawyer and get involved in family disputes, but that's why I said this was a general conversation.
I'll tell you what,
right?
that 25 minutes flew.
Yeah.
That went real fast. I was like sucked into all this thing. Dang, man, it's so complex. And ladies and gentlemen, you need to, if you're not calling, you're wrong, because you've got awesome attorneys coming on here, and they'll answer your questions, and it doesn't cost you. They don't know where you live. They can't send you a bill, so it's all free information. But anyway, the number here is 254-697-6633. I can burn another couple of minutes if you got.
Yeah, look, for stalking, just know you're going to have more than one episode, and you're going to need to show that it was directed at you. Yes, I've had police go after people for sending stuff like birthday cards and wedding invitations, and when the person, and that's a question. Is mail a restricted order in the sense of you broke the plane at 300 feet? Look, man, in my opinion, those kinds of cases have no business being filed in a criminal court and are completely unreasonable, and that's just where the state and I have vast disagreements, and I'll fight the state at every turn on that under the First, Fifth, Fourth Amendment, 14th Amendment, right to liberty and just to be happy. Okay, you got a right to try to reconcile your relationship with family. You may not have a right to send repeated text messages, but to send Christmas cards, Easter cards, birthday cards, for you to go after somebody for harassment or stalking in those situations is outrageous in my opinion. But at the same time, right, when they tell you to stop contacting them and you send them a message like that right after that's your own fault. You're putting yourself in a bad situation. So if you're having more than one contact, right, and it's directed at you and it's a scheme, right, to basically make somebody feel threatened, or maybe not even necessarily threatened with bodily injury, but threatened in such a way that it really affects their daily routine, that's when you're getting into some hot water.
Okay, let's wrap this up. Ross, it was awesome, even though it was so vague. It was very informative. So we can figure out, maybe I'll get some emails and questions and stuff like that. But
that would be helpful, more specific questions, and that's the world I live in the gray, especially with the.
I'll tell you what, though, on May 12th, I'm going to hit this up again, but on May 12th, we've got an all-ladies show, and we're going to have all different topics. Not really, it's going to have a main theme. It's going to be woman-related, basically, but in the attorney segment, maybe we can touch on that, too, coming from a female perspective, as well as also knowing the laws too. So I'd like to touch on it again with you, and then maybe we can even touch on that later on.
That would be great. That sounds pretty good.
All right, Ross, tell them how they can get a hold of you.
Right downtown, 105 East Main Street is my primary office address here in Cameron, Texas. It's in Houston and Bryan College Station by appointment. You can call me at 254-605-4140. That's 254-605-4140. Or you can email me with any of these questions. Maybe, Matt, you want to know some more at Benton, BENTON, @watson.legal. That's Benton @watson.legal. I appreciate you being here. Thank you, Rick Dodd. It's always a pleasure.
Between you and Rick, man, it's a 1-2 punch. It's awesome having you guys on here, so we appreciate it, and thanks for the sponsorship. All right, Trey, let's take us out. When we come back, we'll have a litany of dates coming up that you can participate in with Aaron. See you on the other side. That was good, Ross.